Okay, thank you. You're free to go. Make that notation, please. Felicia Freddie.
All right, I'm going to this morning. We've got getting ready for this other trial this afternoon.
Good morning. You're Felicia Freddie. And Miss Freddie, this is an MTRP and cause number 24 DCCR 1390. What is the announcement?
Judge, if we could have a few minutes, I think I'll be able to get this resolved today.
Okay, sure. I'll hold
It's
it.
an MTRP, Judge. So.
Thank you. Just have a seat, ma'am. Okay. And then you've got Miguel Martinez, Mr. Gertz.
Yeah, Judge. He's present.
Right, so you're Miguel Martinez. This is 25 DCCR 0584. Mr. Martinez charged with aggravated sexual assault of a child. And what is the announcement?
Judge, the state made us an offer and we have made a counter offer in the case. And I think the state needs to get input from the family, is my understanding. And so they're not saying no, they're just saying, let us check. So I don't know if you want to do 2 weeks or 3 weeks.
I'm going to do 2 weeks. It'll be the final reset. It looks like this has been about a year.
There is a possibility that I'll be in trial in Lufkin and federal court on that day, but we will let
Just
you know.
let us know and we can push it a week or two if we have to. Make sure you stay in touch with Mr. Gertz so that once he visits with Ms. French, you guys know, because this will be the last reset for an announcement.
Yes, Your Honor. Still balls popping.
Yeah, and Dan Church.
Oh, yeah. And
It's a bond hearing, right? Dan Church. That's with Ms. Malfino. Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge. That's my error. I was trying to file it rather quickly after receiving the affidavit from the complainant, and I'll fill the court in on that as to why I don't have a witness present.
looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit is very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing. And I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Fays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, et cetera, because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of the amount for this allegation as it stands right now, or as it's indicted right now. I would, Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with complainant, not possessing any weapons.
Those are already conditioned.
Right. I'm not sure what else. Given what else the court could impose, because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's, hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
No, I think
that I'm aware of, or that
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too if I lived across the street and that had actually happened. So,
but I just don't think raising his bond and just charging him more fee is the proper remedy for that. So I'm not sure how the court remedies that, and I don't see what
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you. Here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand? So if they feel uncomfortable, they're going to let Ms. Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense? Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement. Okay. You're free to go.
Thank you.
Oh, here. One of those is just what I printed out. Do you want the exhibit or does that go in the file?
I need to put
That discussion supports my face. Why don't you work on those other two and I'll call Mr. Stovall in just a few minutes.
Miss Grace.
Mr. Gregory. Let's see, Mr. Price and Mr. Rennick
Yes, Judge.
on the expunction for Vincent Ponteri.
Right. Yeah. That expunction should have been filed on that, because that was a mistake.
Okay.
It should have been a petition for non-disclosure, and I paralegal filed it.
Oh,
So that
okay.
was our mistake.
All right. So, if you would, I guess, just, file some type of motion to dismiss that when you
Yeah,
file the,
I thought that was a mistake not there, and I should have caught it. And I didn't.
okay, perfect. Thank you.
We be excused.
Yes, thank you, Mr. Price.
Thank you, Steve.
It's your top. And are you ready on your sentencing?
Yes.
On Amber Bruno Walker?
Yes, she's present.
How are you? Good. Sure.
We see.
Good morning. You are Amber Bruno Walker. And this is cause number 25, DCCR 1814. Ms. Bruno Walker was previously in court, entered a plea of guilty to the state jail felony offense of driving while intoxicated with a child passenger. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have your own.
The state has chosen.
Are there any additions or corrections?
None from the defense trust.
No additions or corrections. However, I do have a comment or a question.
Sure.
And it relates to the defendant's version on page 2. Your Honor, I don't know that it's a full-throated admission of guilt. She refers to this incident as being a distracted driving incident, when in reality it was a rollover crash. She was essentially not cooperative and required a blood search warrant to get her blood.
I made note of that as well.
Judge, I would add to that, though, is, she did acknowledge in that same thing, although it's not lengthy that they listed, she did also acknowledge in it that this was her responsibility. She said, that's responsible for.
I mean, you tested your blood alcohol by the time they finally got it was 0.0986. I mean, so you definitely were above the legal limit. Are you disputing that?
No.
Okay. So, Ms. Bruno Walker, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated on for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. So you're going to be regularly tested. The police version is that it rolled over.
It's what we do.
It did not roll over. Okay, that's just a. So,
Just so the record's clear, Judge, I got part on here. I'm short to Mr. Rennick as well.
okay. How's that not a rollover?
It's not. It's nothing to out.
I thought rollover mean like,
Well, it wasn't on all four wheels, was it?
Yeah.
While you had a child in there. So here's part of the important thing about probation is in order to be successful, you've got to completely take responsibility for everything you've done, all of the conditions that you're going to have to do. It gives me some concern that there's some diminishing of that by you right now. So it is very important that you take advantage of everything that you're about to have to do on probation, because if you don't, you're going to be right back in here and you're going to be looking at that 2-year sentence. You understand? So you are, do you currently have the auto ignition device on your vehicle?
yes, I do.
Okay, so you'll make sure and keep that. Obviously, if there's any blows into that are positive for alcohol, it's a violation of your probation. If there's any issue and probation feels like you need anything more than just regular probation, you'll immediately be referred to treatment, whatever that is. It will be ordered by the court. You understand? You can't have a single drink of alcohol while you're on probation. And obviously you can't do anything else, whether it's legal or illegal, without a prescription. If you do everything you're supposed to while you're on this probation, this is a great opportunity because you'll be able to serve that 2-year sentence that you received while you're out on probation instead. But the other side of that is if you violate any condition of probation, you can be brought back into court and you can be your probation revoked and facing that 2-year sentence. You understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rennick. All right, you just need to have a seat here in the courtroom. Yes, ma'am.
Occupational hazard.
Talk to your attorney about that. That's filed somewhere else separately from this. And so have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thank you.
Judge. Thanks.
They're all like, not me. It's Monday morning. I'm sleepy too. Which one is it? Which one is it? Do you know his name? Sleepyhead, who?
Well,
John Gray?
John Gray.
John Gray? John Gray?
John Gray. John Gray.
Good morning. You all right, Mr. Gray?
I can't have your thought.
You okay this morning? Why are you sleeping?
Work.
Work. Have a seat in the jury box. I'm gonna get you tested this morning to see if there's anything in your system. Mr. Lewis, you've got Treasurer Harris. It's a sentencing.
See, back row. Read it.
Good morning.
Good morning, Jim.
Good morning, ma'am. You are Treasurer Harris. And this is cause number 24, DCCR 1482. And Ms. Harris was previously in court, entered a plea of guilty to unlawful carrying a weapon in prohibited place. I've received the pre-sentence report. Have you both had an opportunity to review that report?
I have, Judge.
Hi, Ron.
Any additions or corrections?
No, ma'am.
Judge, other than the fact that this court has already admonished her several times about possessing a weapon and not being on the property of Lamar University, which I think she is no longer involved.
Yeah. Okay. All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes not possessing a weapon. That includes if someone else has one and they hand it to you, or, this situation, you're 2 semesters away from graduating college. You've got to be looking and thinking, how stupid of a decision to make, to not just do it, but let's put it all over social media. It could change your life, and it has, hadn't it? So I want you to be successful. We all do. There's no reason for any of us to think that you're not going to be successful, but it's very important that you follow all of the rules and conditions of probation. So you'll be on that 3-year deferred. If you do everything you're supposed to, this is such a great opportunity because you don't have a felony conviction on your record. Having a felony conviction will change your life in very negative ways. Lots of colleges won't even accept you. And so do everything you're supposed to on the probation. If you do everything you're supposed to, get that community service done up front, pay your fees, do everything correctly, you can even get off probation early. That happens all the time. It's going to be up to you though. So if you don't do everything you're supposed to on this probation, if you violate any condition, you can be brought back into court, found guilty, which means you'll have a felony conviction on your record. And then you can be sentenced anywhere in the range of punishment, which is between 2 years and up to 10 years. So you need to take advantage of this, because I can tell you right now, anything that has to do with guns at this point is obviously being taken extremely seriously in our county. If you're back in here and the underlying offense has something to do with a gun, even though you just held it and did whatever you shouldn't have done with it, you're likely to go to prison for a long time. So nobody wants that. So do everything you're supposed to. It's harder when you're young because your friends are going to be going out and doing certain things that you're not going to be able to do. But these are decisions that are going to affect you long term. So think long term and not short term. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you. Get those last 2 semesters done and graduate. Okay. Okay. Davion Mason. Good morning, sir. You're Davion Mason. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Mason, in cause number 25 DCCR 1511, you're charged with the state jail felony offense of burglary of a building, and that's from August 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you made is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Mason's not competent?
No.
Is there any issue with restitution?
I have the restitution amount, but I would ask the court, please, just
Go ahead
because
and
of
get
my
one.
prior dealings with Mr. Mason, would you please go to PSI?
Yeah, so
It's
Mr. Mason
$2,000. There is a co-defendant that I would make
Okay.
incumbent upon both.
needs some more information on that. So Mr. Mason, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If there's any restitution, we'll discuss that on that date as well, okay? On your way out of the courtroom today, you need to stop and talk to the probation officer. She's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
See, Mr. Lewis, you've got Lance Charbino.
Yes, ma'am. Sorry.
Do you have his? Oh, that's David Mason. Never mind, sorry. Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino is charged in cause number 25 DCCR 0096 with credit or debit card abuse. And what is the announcement?
Judge, we have a resolution in place that's going to require some upfront restitution. So we're asking for some additional time for them to come up with that. About 45 days should be enough for them to do that.
Smoking eye.
I have no objection to that. Judge, we've offered to reduce it to a misdemeanor based on his having no criminal history. If he'll pay that up front, I believe it's about $5,000.
So here's the thing, Mr. Charbino, I'll do a 45-day reset. Give you some time. If you can get the money together, great. Sounds like that's a great deal. If for some reason you can't, I'm not going to keep resetting it for that. You guys will have to talk about some other resolution.
Yes.
Okay. So do what you can, but I will give you 45 days on that.
Yes, ma'am.
All right. Thank you. You're free to go. Richard Volry, it's a sentencing, Mr. Lewis and Ms. Malfino. Good morning, sir. You're Richard Golry. And Mr. Golry was previously in court on cause number 25 DCCR 1746, entered a plea of guilty to aggravated assault with a deadly weapon, a second-degree felony. And that was
Mr. Walker, Clayton, fresh out, and Mr. Gaines,
who?
McLean.
Okay. And so where are you on being able to get someone hired?
All their price was too high. And Mr. Walker just told me it was too expensive. So,
Are you working? Why not?
I was working out of town, so I couldn't go out of town and come back.
Gotcha. So thank you for talking to those lawyers, Mr. Gregory. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true, and then I'll take a look at it, okay? Step in front of the clerk on the end. She'll give you that paperwork. Tyrania Johnson. Good morning. Thank you. Is it Tyrania?
Tyrania.
I say it wrong every time. I'm sorry. Ms. Johnson, were you able to get a lawyer hired?
No, ma'am. I have a reason. Well, I did talk to three of them. I talked to Mr. Rojas, Mr. Joseph, and Mr. Wrights. But in the process of me talking to them, I had courts, and they told me I was going to combine it with this court. And she told me that I was going to get an attorney appointed to me.
What other court do you have?
I had it. It was my misdemeanor. They told me they didn't want to interfere with this because it's dealing with it. So she told me they was going to combine it. But when I messaged her,
Who is that? Who told you that?
British.
Okay. So typically what that means is usually they'll handle your felony first, but you still, it doesn't get combined in one court. So I don't want you to misunderstand. So if you have a court date down there, you still have to go. So sometimes they'll do things with your cases that are kind of similar, but it's definitely two different things, two different courts. Okay.
Good.
So are you working? Are you able to hire someone?
Yes, ma'am, like that.
You think you'll be able to hire someone?
Yes, ma'am.
Okay, so if I give you one more reset, can you get that taken care of?
Yes, ma'am.
All right, so make sure when you go, let them know that you do have both of the cases, one in felony court and one in misdemeanor court.
Okay.
But this one is definitely the one, obviously, that's more serious to make sure you try to get someone hired.
Okay.
If for some reason you can't, talk to at least 3 others, bring me those names, and then we'll discuss your options, okay? All right, step in front of the clerk. Cedric Martin Harris. Good morning.
Good morning.
You're Cedric Martin Harris?
Yes, ma'am.
And Mr. Harris, this is your initial appearance. In cause number 26, DCCR 0421, you're charged with the state jail felony offense of burglary of a building, and that's from February 4th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Martin Harris, is reset your case for about 30 days to give you some time just to see if you can hire someone. If you do get someone hired, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're not able to hire a lawyer, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options.
Yes.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? Okay. Step in front of the clerk right here. She'll give you a reset. Jurikia Holland. Good morning. How do you say your first name? Jurikia, and you're Jurikia Holland?
Yes, ma'am.
And Ms. Holland, this is your initial appearance in cause number 26, DCCR 0386, You're charged with a second-degree felony of aggravated assault with a deadly weapon, and that's from February 5th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
So what I'm going to do, Ms. Holland, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. Y'all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. You understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice.
Mr. Cody? Yeah.
Keyshawn Spriggs. Good morning. You're Keyshawn Spriggs.
Yes,
You
ma'am.
look very nice this morning, Mr. Spriggs. Mr. Spriggs, this is your initial appearance and cause number 26 DCCR 0665. You're charged with indecency with a child, and that's from March 4th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. I have a constellation on the 17th with Mr. Marcus Wilkerson.
Okay,
Yes.
so what I'll do, Mr. Spriggs, is reset your case for about 30 days to give you some time to see if you can get him or someone else hired. If you do get Mr. Wilkerson hired, make sure you bring the reset notice that you get today to him, and he'll tell you what to do.
Yes, ma'am.
If you're unable to hire him or someone else, make sure you visit with at least 3 others. You'll see that they all charge different amounts, different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step right here in front of the clerk. She'll give you a reset.
Would he just make that?
Joshua Tyree. Good morning. You're Joshua Tyree. And Mr. Tyree, this is your initial appearance. You have 3 cases. Cause number 26, DCCR 0078. You're charged with unlawful possession of a firearm by felon, and that is from September 21st of 2025. And then in cause number 26, DCCR 0079, you're charged with the 3rd-degree felony of tampering or fabricating physical evidence with intent to impair, also from that same date. And then in cause number 26, DCCR 0080. Just a second, get that. You're charged with the 2nd-degree felony offense of possession of a controlled substance, also from September 21st of 2025. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
No.
So your indictments also allege 3 prior felony offenses, which mean all of these you will be considered a habitual offender, which means if you're found guilty, your punishment range is a minimum of 25 years up to 99 years of life in prison. You understand?
Yes.
So it's very important that you try to get someone hired before that next court date. I want to reset your case for about 30 days to give you some time to try to hire someone. If you get somebody hired before the next court date, just bring the reset notice that you get today to that lawyer, and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you will go back to jail. Do you understand?
Yes.
Also, was it a requirement that you were told that you were to wear a drug patch?
Yes.
And you have that on? All right. So it's very important that that drug patch is obviously negative. I get those results. So every 2 weeks, you have to go get it changed. Make sure you get it changed on time. and that it's negative. If there's a positive result, your bond's going to get raised and there'll be a warrant. You'll go back to jail. Okay.
Yes.
All right. Step in front of the clerk. Darian Broussard.
There's actually wasn't a community officer.
I've got good morning, you're Darian Broussard. Give me just a second, Mr. Broussard. Let me read this real quick. So when you were here last time,
And that brings this courtroom session to a close. Today, we saw just how quickly a case can turn on a single legal decision, a plea agreement, or one condition of probation. Some defendants were given an opportunity to stay out of prison, but those opportunities came with serious responsibilities and serious consequences if they fail. From the motion to suppress, to the 10-year suspended sentence, to deferred probation and the warnings about violating court orders, the message from the bench was clear: second chances are possible, but they come with conditions. Now the real question is, will these defendants make the most of the opportunities they were given, or will we see them back in court facing even tougher consequences? What do you think about the judge's decisions in these cases? Let us know in the comments, and if you enjoyed this courtroom breakdown, make sure to like, subscribe, and turn on notifications for more courtroom moments and legal analysis.